Since all attempts to negotiate with Electroace have failed, and arbitration seems the best move, Asianix has decided to seek legal advice on how to proceed. Its General Counsel has set up a meeting with a prominent offshore practitioner who is familiar with Singapore arbitration practice to discuss what should be done.
Well, first order of business, Merry Christmas.
Thank you very much and a very Happy New Year.
Thank you, and again, thanks again for meeting me so urgently despite the festive season.
Not at all. I think the issue in Zarasia seems like it's pressing and that we may have to act quite quickly.
Yeah, absolutely. I mean, how would you suggest we handle that? We've tried everything. Electroace just refuses to sit down and see our position.
Well, then maybe we need to go for something a little stronger.
I think yes, indeed, because, I needn't remind you, but there's a lot of money and reputation at stake. There, I've just reminded you anyway.
Not for the first time. Maybe what we should do is initiate an arbitration. The contract provides for arbitration in Singapore.
Yes, under the rules of the Singapore International Arbitration Centre, but how would we go about that?
Actually, it's quite simple. Putting together a notice of arbitration is a simple exercise. It's a straightforward process, and it's often done actually to apply a pressure point to the other side. It may be that once they receive a notice of arbitration, they might think it's appropriate to begin settlement discussions.
And in your experience, that usually works?
Often it does.
Okay, well, then it works for us. Let's try that.
According to SIAC Rule 3.1, a notice of arbitration can take the form of a physical letter or even an email. It must contain the following. 1. The contact details of the parties to the arbitration and their legal representatives if known. 2. A reference to the arbitration clause or the separate arbitration agreement that is invoked. It should also provide a copy of the clause or agreement. 3. A reference to the contract or treaty out of which the dispute arises. Again, a separate copy of such agreement should be appended to the notice. 4. A brief statement describing the circumstances of the dispute and the relief claimed. Further, where possible, an initial quantification of the claim amount may be mentioned. 5. Any comments by the claimant regarding the applicable law, the language of the arbitration, and proposals in relation to the number of arbitrators or nominations of persons to act as arbitrator if the agreement does not provide it. 6. A demand that the dispute be referred to arbitration. 7. And finally, of course, it must be accompanied by a filing fee, as provided for by the SIAC Schedule of Fees.
There will, of course, be a filing fee, but your outside legal team can take care of that.
Okay, all of that is fine, but, I just realized there's actually something even more urgent.
The performance bank guarantee.
Precisely. It's in the contract, and Electroace might decide to encash it at any time.
So we will need an injunction to stop that happening.
So what, do we have to go to the courts of Amazonia or Zarasia? We don't know anything about the courts there.
Actually, there's no need. We can go to the arbitration. We can ask an arbitrator to make an interim order.
Go to the arbitration, but what arbitration? We don't even have an arbitrator.
That is true, and of course your contract stipulates 3 arbitrators, so that would ordinarily take a long time to put together. But there is a process available to ask for an emergency arbitrator.
And the SIAC can do that?
Actually, the SIAC was one of the first institutions in the world to introduce this kind of scheme. So it's a mechanism whereby you have an arbitrator put in place very quickly who is able to give interim measures of protection. And in this case, one can hope that the order might be to prevent encashment of the guarantee. Certainly as far as I'm concerned, there is no contractual basis to encash that guarantee.
Well, I hope you're right, because if it's going to take weeks or even months to get this emergency arbitrator appointed, then we're simply going to be too late to stop them.
Just calm yourself a little bit. Christmas is a time of miracles, and as you well know, when my fees are paid on time, I can work the occasional miracle. Actually, as it happens, in the SIAC, you can get an emergency arbitrator in place in 1 business day.
1 business day. Are you sure about that?
I am sure, and in fact, I've heard directly from the CEO of the SIAC that in almost all of the cases so far, they have managed to meet that target. That is, to date, 36 cases.
That sounds almost too good to be true. Are you sure there's no sort of dark lining along the silver clouds? I mean, what if we don't get the relief we want?
It's possible we don't get the relief, but worst come to worst, we will actually just apply to the main arbitral tribunal when that's constituted in due time. And if the guarantee has been encashed in the meantime, well, then we'll seek monetary relief.
Okay, so what are our chances for that then?
Of preventing encashment, well, my definitive view on that is it depends. When I look at the guarantee, it says that it is provided in favour of the Electro-ACE's subsidiary, Electro-Oceania, through an Indian bank. Maybe you can just explain to me why that structure is in place.
Well, why Electro-Oceania? Well, as far as I understand, that's probably because they handle Electro-Asian's contracts. And as to why an Indian bank, again, that's probably because Electro-Oceania's got assets in India and probably some sort of an office there.
Well, it gets a little bit worse. The bank guarantee is drawn through the LBS Bank in New Delhi. And what complicates things is that the bank guarantee expressly provides that it's not open to the guarantor, which is you, to know or investigate the merits of the demand invoking the bank guarantee, or even to challenge the demand.
Exactly. I mean, that's what I don't understand. We can't even require proof of our liability before we pay. We just have to shut up and pay the amount demanded.
And the bank guarantee also provides that the invocation shall be binding on the guarantor, and that the invocation shall not be affected in any manner by any dispute that the guarantor may raise. What we should do is check whether or not we can apply to the courts in Oceania or in India to prevent this encashment.
Okay, let's hold on now. Even if there may have been some defects in the components we supplied, and let's say Electro-A suffered some sort of damage, from that, how does that entitle Electro-Oceania to encash the bank guarantee?
Unfortunately, the wording in your contract clearly identifies Asianics as the guarantor and Electro-Oceania as the beneficiary. Fortunately, the contract does provide that the guarantee can only be invoked in the event of a material breach of the agreement by Asianics. So what I suggest our strategy should be is to convince a court or an emergency arbitrator that unless and until that question of material breach is actually determined, there cannot be a valid encashment of the guarantee.
Well, I'm not so sure about that. My fingers are going to be very tightly crossed on this one.
Well, whilst your fingers are tightly crossed, what I suggest is first thing tomorrow, let's consult with counsel in Delhi and see whether or not we can bring this matter before the Indian courts. I have in mind an extremely expensive but extremely good counsel in Delhi.
Okay, fine. Let's just see what she says and then we can decide. Well, anyway, I think we should get something to eat first.
Now that will definitely clarify our thinking. Excuse me.
I agree. Zuracia seems to be getting a very tricky position.
You've seen the papers?
I have seen both your papers and the papers. They both look tricky. How can I help?
If I can just cut to the chase, we are extremely concerned about the bank guarantee under the supply contract. We have every suspicion that Electro-Oceania is going to seek to encash that guarantee based upon supposed counterclaims, albeit, at least in my view, those claims are extremely dubious at best.
The contract does seem to be in their favor. Are you seeking to apply for an interim measure of protection against encashment?
That is exactly what we're seeking, but we need your assistance. We need to know what the position will be in India, and in particular, whether we can or should apply to the Indian courts.
Well, the Indian position with respect to the encashment of bank guarantees is courts should be slow in enforcing the bank guarantees with respect to a beneficiary's right, especially for an unconditional on-demand bank guarantee. This position is based out of a proposition that an issuing bank need not unnecessarily get into the underlying dispute between the parties. In fact, in India, when a bank issues a bank guarantee or a guarantee is given by a bank, then it is strictly prohibited for the bank to go into the legitimacy of a beneficiary's claim.
So that sounds like that's going to work against us in the Indian courts.
Well, I suppose then there's a question of whether we're allowed to even approach the Indian courts at all, seeing as the supply contract contains a clear arbitration clause.
Isn't it the position that the Indian courts have to entertain any application for interim measures of protection? And as far as I understood the position, the Indian law is based on the Uncitrall model law.
Yes, Section 9 of the Indian Arbitration and Conciliation Act is modelled on Article 9 of the Uncitrall Model Law, thereby granting the power to a party to approach a court for an interim measure of protection with respect to an arbitration in India.
Okay, good. So this sounds like there's no problem.
However, some of the Indian courts have had to consider whether an Indian court would have an jurisdiction to deal with the question of interim measure of protection with respect to arbitration seated outside of India.
Ah, I see. So there is a problem.
Well, you see, the Indian Arbitration and Conciliation Act is divided into two parts. Part 1, which deals with domestic arbitrations, and Part 2, which deals with foreign arbitral awards and its enforcement in India. Fortunately, a 2002 Indian Supreme Court decision had the opportunity to look into the question of a granting interim measure of protection with respect to arbitration seated outside of India, and they did go ahead and granted that power to an Indian court. In fact, there has been decisions of the court where they have permitted parties to apply and granted interim measures of protection even before an arbitration has started.
But presumably in that case, one would have to show an intention to actually commence the arbitration.
Oh, precisely.
Well, then that's exactly what we need.
Something tells me that it's not going to be as simple as that. Is there anything more?
Unfortunately, there is. The same Supreme Court decision also said that the parties have the power to oust the jurisdiction of the Indian court if they impliedly or expressly provided so in their contract, which implies that while entering into a contract, if by an express or an implied exclusion, the powers of an Indian court to grant an interim measure of protection could be taken away.
But our contract doesn't say so.
Not expressly, no. But our arbitration agreement mentions SIAC and Singapore. There have been court decisions where the courts have interpreted a foreign seat or a governing law other than the Indian governing law to imply an implied exclusion of Part 1 of the Indian Arbitration and Conciliation Act. In fact, I should mention that a recent 2012 5-judge decision of the Indian Supreme Court have held that an Indian court would not have any jurisdiction to grant an interim measure of protection with respect to arbitrations seated outside of India.
Oh dear, that doesn't sound very good for us.
It depends, because this decision of the Indian Supreme Court only applies to arbitration agreements signed on or after the date of the decision, which is 6 September 2012.
Ah, good then. Fortunately, I think ours was signed on December 2011.
Still, knowing the bad faith scoundrels on the other side, I have no doubt at all that Electro Ace will throw that Singapore-based arbitration agreement right back at us if we make any attempt to move before the Indian courts.
Well, I've no doubt that you're right. Anyway, another question I have is how long is this application going to take before the Indian courts anyway? I mean, I know they're notoriously backlogged and really timing is of the essence here.
Good question. It should take about 3 to 4 months for the application to be finally heard by the Indian courts, but that is after all the submissions have been filed by both the parties. However, if we were to apply for an ad interim ex parte injunction, that should be fairly quickly. Having said that, you might want to consider before going to an Indian court that is Asianix okay to have it publicly known about their dispute with the Eurasian contract?
No, that's totally out of the question. This is one of our biggest orders in the past 5 years.
I thought as well. It might be of interest to know that SIAC clauses in an arbitration agreement situation, the Indian courts have actually refused granting an interim measure of protection because of the reason that the parties have an SIAC option available and also because of a mention of a foreign seat, which implies an exclusion of Part 1 of the Indian Arbitration and Conciliation Act. Furthermore, the Bombay High Court has recently validated an SIAC emergency arbitration order passed by it.
Well, thank you very much. That all sounds extremely problematic. I think we are now focusing on the SIAC route and the emergency arbitrator option, but we'll certainly keep you posted as we decide.
Yes, please. Let me know if you need to give a shot at the Indian courts. We could hire a senior counsel and try and get an interim injunction. Having said that, I know that SIAC has dealt with a lot of emergency arbitration applications involving Indian parties, and the results have been quite impressive. Considering an emergency arbitrator application before an SIAC is definitely a real and meaningful alternative.
Perfect. Well, that's all I want for Christmas then.
On that festive high note, I shall say goodbye.
Thank you very much.
Good evening, gentlemen. Merry Christmas.
And a Happy New Year to you.
Well, I think the writing on the wall is clear enough. I think the Indian option is extremely problematic. I think we should now go the SIAC route. We should commence SIAC arbitration straight away. We should request the appointment of an emergency arbitrator and apply for emergency interim relief.
Yes, I think that all sounds very sensible. I'm happy with that. Let's go ahead quickly.
In terms of the next steps, if I just set them out, we'll draft a notice of arbitration that will be filed with the SIAC, and they will then check the notice to see that it complies with all the requirements of the rules. They will then send a copy to the respondent, and then they'll set out the next steps of the process.
All right. Well, I've got another question.
Well, that's no surprise at all. What is it?
If the arbitration is actually seated in Singapore, but let's say Electro Ace's assets are in China and South Korea, how sure are we that the decision of the arbitration tribunal is even going to be enforced?
If I can give you a very clear answer, we're not sure. As any lawyer will tell you, it all depends. Enforcement can be problematic. It can be difficult in some jurisdictions. Sometimes defences to enforcement are raised, other challenges. But what one can say is that institutional arbitration can be much more secure than ad hoc arbitration. SIAC in particular has a very good reputation. It's a well-known body. It has well-respected comprehensive rules. It has a very good system, internal system for scrutiny of awards. So I think with an SIAC award, we will stand better chances of enforcement than otherwise. And hopefully we'll find a jurisdiction with a newer convention implemented where there'll be no available defence to enforcement.
All right, then. Well, I suppose now we come to the most important question, which is really how much is this all going to cost us? I mean, not just the emergency arbitrator, but the entire case.
Well, in terms of the entire case, SIAC will set a maximum for all the costs, and they'll notify that to all the parties.
Costs of the arbitration. Rule 31, SIAC Rules 2013. 1. Tribunal's fees and expenses. 2. SIAC's administrative fees and expenses. 3. Costs of expert advice or other assistance required. The total costs of the arbitration can be calculated using the fee calculator on SIAC's website. The three components are the tribunal's fees and expenses, SIAC's administrative fees and expenses, and the costs of expert advice or other assistance required. As for the costs of expert advice and other assistance, this is estimated initially by adding 20 to 25% of the total of the tribunal's and SIAC's maximum fees. The ad valorem basis on which the first two components are calculated helps provide certainty to parties and increases the efficiency of the arbitral process. Whether a tribunal spends 400 hours on a case or 4,000 hours, it does not mean it is paid more. After all, SIAC believes in objectively assessing a tribunal's fees based on the work actually carried out in each case. However, in the spirit of party autonomy, Rule 30.1 offers the parties the option of alternative methods of calculating the tribunal's fees. When we add the three components, we arrive at the maximum amount that the arbitration may cost, giving both parties some certainty at the very outset. In reality, however, the arbitration may cost significantly less based on the stage at which it concludes, the time it takes, and the complexity of the dispute. To ease payment burdens, SIAC divides this amount into three tranches equally shared by the parties: 35%, a further 35%, and finally 30%, which are spread across the different stages of the arbitration. The first tranche is payable immediately when a case commences, in order that the arbitration can proceed. If a respondent fails to pay its share, then the claimant may have to pay on the respondent's behalf, subject, of course, to being able to claim these monies subsequently once the tribunal has ruled on costs. Furthermore, although deposits paid to SIAC are to be borne equally by the parties, the tribunal often decides that all costs are to be borne by the losing party.
Okay, and so what about the emergency arbitrator's fees?
Well, that has a number of different components. Firstly, there is a flat fixed fee of 5,000 Singapore dollars, which is an administrative fee at the outset. There is then the question of fees of the emergency arbitrator, and that is subject to a cap, which is 20% of the normal arbitrator cap. There is also a minimum amount, which is 20,000 Singapore dollars, but that's subject to the discretion of the registrar. Do bear in mind, of course, that the maximum that is set by the SIAC for the arbitration costs is just a maximum. At the end of the day, the actual costs, once quantified, may well be less than that.
Well, that's music to my ears. I suppose then we've got to deal with the other issue, which is your rates and how much you're going to charge us for all of this.
Now, those have no maximum. But as you know well, they are always extremely good value for money.
Oh, my ears.